Hi, my name is Jessica Lopez, and I'm a business and commercial litigator with the USLAW member firm Roetzel and Andress, and I'm here today to talk to you about litigation avoidance. You've probably heard of the concept, but oftentimes I find that key employees within organizations view the concept too narrowly as only encompassing ADR and mediation. While ADR is certainly an important part of the litigation avoidance concept, a true understanding of the concept is much broader, and it involves changing internal practices and policies before or immediately after a dispute arises. So with that, let's jump into my top 10 tips for avoiding litigation. Number 1, implement and promote immediate reporting procedures. The opportunity for litigation avoidance is often missed because companies don't implement any formal written reporting procedure. What happens when this occurs is that results in employees often trying to fix the problem before management learns of it. And sometimes when they do that, they can put pretty damaging statements in writing that can be imputed to the company or set the company on a course that can be really hard for us outside counsel to defend in any subsequent lawsuit. Number 2, implement and adhere to claim investigation, and of course, get legal involved early on. Early claim investigation is the core to successful litigation avoidance. When legal gets involved, we obviously can maintain and protect certain portions of the claim investigation with the privilege, and we can also do certain things to protect the company from a preservation standpoint with respect to issuing litigation hold notices. Number 3, what employees say and do matters. Though it may not be their intent, employees may create and impute potential liability to the company through their words and conduct. I found in many of my cases that social settings, such as customer entertainment, is really a breeding ground for this issue. Obviously, text messages and other social media communications are also discoverable in the modern day of discovery, even if deleted. Number 4, function as a team. The right hand really needs to know what the left hand is doing. Otherwise, in our experience, we've seen contradictory documents being created on behalf of the single entity, which really becomes hard to explain or defend in any subsequent litigation. Number 5, do not assume responsibilities in excess of job duties. Employees have to be taught and really coached that acting outside the scope and course of their job duties may create potential liability for the company. And this is really important with companies who employ specialized employees like engineers who may be held to a higher standard of care. Number 6, know the standard contract documents, but of course don't act like a lawyer. Depending on the specific business, key employees really should know what's in and what is not in the company's standard agreements. Otherwise, obviously, they can create additional entity liability or act in a manner that may be contrary to the company's legal obligations. Number 7, objectivity is key. Business disputes are not personal, but oftentimes employees, especially those who are very involved in the dispute, make it personal. So maintaining objectivity is vital in a company's attempt to resolve a dispute short of a litigation. Number 8, analyze past business disputes. This is all about trying to find where the company made mistakes or had claims and then identifying lessons learned. If companies continue to see the same type of claim over and over again, they can better identify areas of improvement. I recommend that companies implement quarterly retrospective reviews to identify the areas of improvement with legal. Number 9, contractually shift risks where possible. A company's best friend should be its corporate attorney, who will work hand in hand with the company to prepare standard contracts that will protect the company's best interests. Where possible, standard contracts should be refreshed annually to include risk-shifting provisions such as indemnification, release, and disclaimer. Venue and choice of law provisions should also be considered because obviously those become very important in any subsequent litigation. And I also recommend that companies take a look at their deterrent language, such as prevailing party attorney's fees, to try to deter a party from filing a frivolous claim. Last but not least, number 10, insurance. Companies need to retain insurance counsel to review their current policies to ensure that they're sufficient to meet the current needs of the business. And obviously this changes as the business grows, but if your company is growing really substantially, this is all the more important. General commercial liability and D&O coverage are often both necessary for the specific type of business that you may be dealing with. And as I mentioned in topic number 1, early and prompt reporting is critical for claims-made insurance policies like D&O policies. If a claim is not reported during the policy period in which it arises under these claims-made policies, coverage may be denied entirely for an otherwise insurable occurrence or event. So while lawsuits may be inevitable, properly managing disputes before or immediately after a claim is made is key to litigation avoidance. If a dispute does ripen, adhere to these principles to optimize your company's ability to achieve the best resolution possible, or alternatively, position the company in the best way possible to defend or prosecute a claim. If you're ever in Michigan, my recommendation is that you check out Traverse City. It's beautiful, it's right on Traverse Bay, and it has a ton of really nice wineries, especially up the Leelanau Peninsula. My favorite is Bonobo.